Hello and welcome to the Legal Giant Show. I'm your host, Nicholas Newsom. Today's topics will be the border crisis with the COVID issues going on down there in the southwest border between California and Mexico, as well as the national news we're seeing about marijuana and the overlay between marijuana in the news and the use in the workers' compensation and employment context. If you haven't been paying attention, the southwest border of the United States has been highly restricted as a result of Title 42 under Donald Trump in March of 2020, an issue of restricted crossing for all non-U.S. residents and non-California or United States properly visaed individuals in regards to COVID-19 travel. The basis was to restrict the transmission of the COVID-19 virus, and the data is quite clear that it worked. Now, the Biden administration officials are working on lifting those COVID-19 restrictions. However, there's been some issues twofold down there. One, we're seeing a very large surge again south of the border, specifically in certain parts of Mexico and the Tijuana area, as well as the Biden administration has came out and clearly said that they believe there's going to be a surge of migrants the minute the COVID-19 Title 42 restriction is lifted. As evidence in support of that, if you go to the website which tracks immigration, it'll let you know that over 108,000 of the recent deportees to the southwest border have been as a result of this Title 42 COVID-19 restriction. In comparison, an equivalent number of 45 to 65 at the same time of our northern border in Canada. And so there is a substantial difference between the potential for mass migration influx at the borders, creating a bureaucratic and processing nightmare for the United States Border Patrol administrations that they have set up, because their job is to properly and to the extent they can adequately and timely process claims for immigration or asylum and so forth. And with the border being influx with potential tens of thousands of migrants in a day, while simultaneously having to allow the free passage of many of regular citizens who right here in San Diego live just across the border in Tijuana, but work 5-6 days a week. Sometimes they're here 7 days a week in the San Diego and the greater Southern California area doing highly necessary jobs. And those individuals will be most harmed in this process when there is such an influx at the border. And then there's, of course, the concerns with COVID-19. Specifically, individuals who are in cramped, low sanitation conditions are much more susceptible to this COVID-19 transmission. And if this Delta variant or COVID-19 is still on the rise south of us, in south of the border, it is a matter of national concern. However, what I do have a concern with is when we see the Title 42 restriction being maintained, not because COVID-19 is the concern, as the Title 42 restriction that was issued by Donald Trump under the mandate in March of 2020 and put in place is now being used specifically to deter migration itself. And though they're irrespective of your political opinion on the importance or lack thereof in regards to legal migration or attempted migration, when you have numbers like 178,000 individuals who either expulsed or apprehended to the southwest border in June of 2021 alone, you realize that there's a massive need somewhere in this society or in Mexico's society. And that has to be tendered with the idea that we're supposed to be a nation of laws, and those laws are supposed to mean something, those words on paper. And those of us that are members of the fraternity that have swore to uphold the Constitution, I ask you this question: is it okay to use the bureaucracy of Title 42 to restrain otherwise legal immigration or legal attempts at immigration or migration of these individuals if the COVID concern isn't there anymore. And here I'm referencing a Washington article about the Biden administration. It stated that they're lifting these restrictions for children and some of these parents, but due to the concerns of mass migration, they're hesitant to lift the Title 42 restriction. And I thought to myself, that certainly sounds like the use of bureaucracy. And in some sense, the question then becomes, and not just the use of bureaucracy, but the use of bureaucracy for ill means. I guess it would be the equivalent to an off-label use of a medication. But this isn't what we're talking about here. This isn't a medication. This is a law, and it either says what it says or it doesn't say what it doesn't say. And if the Title 42 restriction is specifically that's in place at this time is for restraining the COVID-19 variant, and Mexico is able to demonstrate that the COVID-19 variant is under control at that area, then I would question the continued restriction specifically underneath that mandate. That's what I would say about that. I also want to segue here a little bit into the larger topic that we're going to cover here, which is marijuana. And, a post is from AEI, which is a foreign defense policy of both Latin America, and for whether or not legal marijuana is going to curb cartel activity. And now they're saying, it was posted in January 2021, that the vast majority of the Mexican cartels, and specifically the Guadalajara cartel, which made most of its, I guess, bones, for lack of a better term, by shipping illegal marijuana, have diversified their legal activities into heroin, into cocaine, and other illegal smuggling operations, such that legalization of marijuana is not going to likely curb much of the cartel's activities, as have been lauded at times. But more importantly, I think the transverse of that coin is, if there's not that much effect on the cartel's activities in the negative, it most likely will not be that much effect, if any, in the positive for the cartels. That is to say, the other side of the coin, where individuals have been claiming that to legalize marijuana would be to embolden the cartels, or to imbue their communities or their organizations with more money to commit more of their crimes. And this article quite clearly says that they've diversified so far out of it that the legalization has actually cut into their ability to profit, rather than will contribute to it. At least that's what it's looking like preliminarily here in early 2021. I will say this, that my personal beliefs in regards to capitalism's power to capitalize on a gap in the market where it has been artificially propped up, where I would argue that the government has been involved in regulating morality, where otherwise time has proven that regulation on morality to either be scientifically incorrect or likely an overreach of the collective freedom of society. And I think marijuana has demonstrated itself that way recently in both medical science and in other aspects. And so it's kudos to capitalism being able to defeat more of the cartels than we've seen any of the individual, I would argue, governmental actions, and that was arguably the legalization of it. So I think the long-term effect of legalization through capitalist aspects have sought to curtail it, whether it's through forced diversification or other aspects, such as reducing the overall profitability, as anybody who's been watching the financial markets in regards to cannabis know that it is absolutely been constrained by a glut in the market. And that is not the business of what drug cartels are in. Drug cartels are in the business of massive profits, right? That's why they originally got into marijuana, because it was a massive profit. And so I would argue that the border crisis that we're seeing, and any connection that individuals are trying to still draw in the business or the legal arena between marijuana and the Mexican cartel, are misplaced, or misguided at the least, and at worst maybe are reminiscent of an era of old that needs to be, gently moved aside, so more progressive and more open mindsets to race and ethnicity and culture can be established here. So when we come back, we're going to cut to a commercial break here in a minute. But when we come back, we're going to talk about Sha'Carri Richardson, and the inability to participate in the Olympics, and now who was once an Olympic gold hopeful will not be. As well as there was an article I wrote about steroids in sports when I was in law school, and it incorporated and covered the Russian WADA drug scandal, which was memorialized in a documentary called Icarus years later. And so we'll start with that right back after these messages. Hello, my name is Nicholas Newsom. I am the founding member and managing attorney of NHN Law Offices, a trial consulting and representative firm in the San Diego, California area. When I got first started in the legal field, I understood early on that relationships and connections were as important, if not more important, than understanding the law. I immediately began to amass myself a network of connections of individuals that I thought were not only high quality and worthy individuals, but people who were trustworthy and would get the job done when needed. I have amassed a large network of fellow attorneys, doctors, investigators, and even some fellow judges who I've consulted at times to be able to propose the best arguments for my clients to provide maximum success ratios, even when taking cases to trial. As a result, if you or a loved one is in need of any legal assistance, please reach out to us at NHN Law Offices. We're here to help.
Have you been hurt at work? Struggling with a workers' compensation claim? Dealing with a heartless insurance company? If you're not receiving disability payments or satisfactory medical treatment, or you're unhappy with your attorney, you're not alone. Unfortunately, many injured employees face issues with their workers' compensation case. Don't be overwhelmed. You have rights. The Sexton Law Firm helps injured workers navigate through the workers' compensation maze to maximize their monetary recovery and prevent them from being taken advantage of by insurance companies. James F. Sexton is a former lead attorney for an insurance company. He knows how the other side thinks and the hidden inside secrets insurance companies don't want you to know. The Sexton Law Firm has a no-win, no-fee guarantee. This means that if we don't win your case, you don't pay at all. Call today. Let the Sexton Law Firm get you the benefits you deserve. 619-870-1688.
All right, welcome back to the Legal Giant Show. We were just covering some of the topics in regards to marijuana on the border before we left, but now we're moving on to Sha'Carri Richardson, banned from the U.S. Olympics team and left off the U.S. track and field team as of July 6 due to a dirty marijuana test. Ms. Sha'Carri Richardson claims that it was overcome with grief due to the passing of a biological parent that she learned about in Oregon, which sent her into a personal panic and caused her to smoke marijuana, which is a banned substance on the WADA list. For those of you who don't know what WADA is the World Anti-Doping Agency that is set up to test professional athletes as well as Olympic athletes around the world on an intermittent and unknown basis to confirm that athletes are not engaging in use of performance-enhancing drugs even during their training periods or during a time frame in which they claim to be a professional athlete, as to avoid performance-enhancing drugs influencing the outcomes in these competitions. I'm not going to get into the subject of whether or not marijuana is a performance-enhancing drug. I think it could be debated on either side. But more importantly, I'm going to touch on the fact that marijuana is now legal in a huge number of states in the United States. In fact, the vast majority of the individual states of the United States have some form of either recreational or medical or some access to commercial grow marijuana in a legal capacity. And as far as performance enhancing drugs are concerned, the use of marijuana can be considered a performance enhancing drug according to the WADA definition. And then the question becomes, how harsh should that judgment be against that drug when I guess arguably alcohol on some extent could provide certain performance enhancing benefits, and yet we would not punish alcohol the same way as we would marijuana in a professional athlete. Also, the Icarus documentary and the drug scandal coming out of Russia clearly demonstrated that the reward vastly outweighs the risk, and that if there is a will, there's a way. Someone will attempt to overpower the system as they did systemically. And although there was huge admonishment for Russia and there was huge backlash for that, and I personally am uncertain if it was actually enough to curtail the conduct, because I'm uncertain for how many years the hiding was going on, or for how long they had been able to perform at that higher level. I will say this: I personally, a personal fan of both numbers and the Olympics, was paying attention for a while and noticed that at some point Russia had gotten really good again. And I remember doing my research and saying, hey, this is reminiscent of, the Cold War era kind of steroid stuff that we were seeing both out of Russia and Germany at that time as well. So for me personally, I think that, especially in regards to marijuana here, it needs to be relooked at as far as what is or is not allowed or permissible. I believe there's a zero tolerance for that substance. I could be incorrect. One of my listeners, please chime in if you know more about the WADA administration rules at this present time. I haven't looked at them since the old glory days of law school. But yeah, before we segue into some of the employment law and marijuana law topics that encompass also workers' compensation, I also want to say that Ms. Sha'Carri Richardson, the reason I personally, as much as I am open-minded about that substance in our society, and having had a grandmother who passed, who at the time marijuana science in regards to cancer patients was kind of barely starting to take off, but their very deeply religious and moral standing was that they would not even entertain that idea. And that always stays with me, in that I think I could have had more time with my grandmother had that medication been explored in a medicinal aspect. And I would have taken even a single day, but some of the science tells me that it might have been enough to not only improve the quantity, but also the quality for up to an additional 90 days. And to have any time with my grandmother would be invaluable to me now, of course. And just giving you my 2 cents on it, that I'm not super biased against that. However, if I was an Olympic hopeful, an Olympic gold medalist, much like I was holding our championship Coronado team to a higher standard to perform as a champion, and quite clearly the rules said that you cannot have marijuana in your system. And while I personally don't judge you for your personal lapse in judgment, you must acknowledge that lapse in judgment and deal with the ultimate consequences. And some of those consequences are, it appears that you're going to be an ambassador for a cannabis brand, which is a signing thing. I think there's, again, it's a beautiful thing about capitalism. One person's demon, as it were, is another person's hero, or as the age-old saying is, and I never liked it too much, but one man's trash is another man's treasure. And so I definitely think there's a way out, as it were, for you. But I can't personally say that the U.S. track team or WADA treated you any differently than they would any other athlete, just simply because of how the rules are written. Now, maybe we need to talk about those rules, especially since, for instance, here in the state of California, it's both recreationally and medicinally legal. So you in California can walk into a store. I believe the rule is above the age of 18. You don't even have to be 21. But somebody double check me on that one. I don't do too much marijuana law. I focus mostly on the employment aspect, but I believe you can just walk right in and purchase it like you would anything else, just with the proper identification and the age requirement. Oh, excuse me. Let me double check here. So it is the age of 21, actually, in California. We treat it like marijuana as alcohol. Other states, actually, it looks like it's 18. There is more than 33 states here in the United States, actually, that allow marijuana in some capacity. And in fact, there's quite a few states that have passed laws in regards to marijuana and workers' compensation, believe it or not. And so I just find it really incongruent somewhat in our society that we allow marijuana, and we even allow marijuana on a medicinal basis, but we treat it as a performance-enhancing drug and not allowed. Yet steroids are permissible even at an increased level in sports if under the administration of a doctor and for healing or medicinal purposes. Yet there is no such leeway for marijuana, and it seems to deny this plant its very capable ability of providing some type of medical benefit to its user. So, for instance, in workers' compensation, most people don't know this. In California, there is no precedence in regards to reimbursement, but there are a number of states out there which allow reimbursement on a medical basis through workers' compensation. Believe it or not, in New Mexico, Maine, New York, New Jersey, they all have rules for reimbursement, which require either a self-insured employer or the insurance carrier to reimburse for medicinal marijuana. So, for instance, in New York, Quigley versus the Village of East Aura, workers' comp insurer argued that they shouldn't have to be required to reimburse for medicinal marijuana as it's federally illegal and also recreationally illegal at the time, and has now since recreationally been passed in 2021 under Senate Bill 854 in that state. However, legislation A06357 in 2014 allowed for initial serious condition use under a medical use, and under that guidance, the court said if it's allowed for certain serious medical conditions, and this type of condition is a serious medical condition, then the workers' comp insurance carrier cannot be surprised that they were forced to reimburse. Same thing in Maine. Knoll versus Lepage Bakeries Incorporated, self-insured employer had to reimburse for reasonable and proper use of medicinal marijuana by an employee. And also in Bourgeois versus Twin Rivers, a company was required to reimburse for the medical marijuana because it was both reasonable and necessary to cure or relieve the effects of industrial injury. Now, here in the state of California, that we have the very same language in regards to medical treatment, that if it's reasonable and necessary to relieve or treat the effects of an industrial injury, then it's a reimbursable expense. But there is no precedence here. New Mexico is really unique in that here in the state of California, we have a fee schedule, and we've been enacting more and more of these fee schedules and refining them as we realize that fee schedules are the best way to clamp down on these out of control prices and really get what is a true market sense, run the numbers, and do the dirty work necessary for the industry to be more fair and level on a playing field. New Mexico has been so far progressive that not only do they have a case which held insurers must reimburse for qualified workers' compensation claims, including the use of marijuana. But in fact, the state has a rule and a fee schedule for the reimbursement of marijuana since 2016. Kid you not, you can look this up. This was garnered from the Mitchell marijuana map. It's available for everyone online, and Mitchell's a known workers' compensation company in the industry, and they have a beautiful nation map. So if you practice workers' compensation in other states or some of these states, you can help and keep your employer and your insurance carrier apprised of their potential for exposure or lack thereof. In transverse, the state of Oregon specifically has a reimbursement that insurers are not required to reimburse for the use of medical marijuana. And I always found that kind of unique when I analyzed the numbers, because they've been one of the first adopters. They've had a medical marijuana act since 1998, very similar to the ones that were proponed here in California. Yet we maintain a considerably more conservative stance on some of these subjects with regards to reimbursement. So what are your thoughts? Tell me. I mean, medical marijuana, workers' compensation in California, what would you say if you were the defense attorney or if you were the applicant attorney? I can tell you that I've never seen my client as a defense attorney ever actually have to pay for medical marijuana. I have heard of other clients willingly pick up the tab for medical marijuana when it was being substituted for a much more expensive opioid, and they just simply did not care when the cost went from $800 a month to $300 a month. Did I think that was personally a slippery slope or could potentially subject them to some other concerns? But I wasn't involved in that decision-making process, and it wasn't a client of mine on either side. I simply got to be in the proximity of it all. But it's food for thought, because rest assured, though we don't have precedents here yet in California, that issue will be tried, especially as we see the opioid and the weaning processes go up. And in fact, there is a case that I have seen recently that does in fact have just that transgression of a type of issue, and it may very well be that it needs to go up and see whether or not the insurance carrier should have to pay for the marijuana on that one, especially if an individual who's been a long time opioid user is being forced to wean and there is no reasonable substitute. I want to bring your attention to some premises liability slash MVA cases issued recently in the last year or two of the Workers' Comp Appeals Board. Specifically, Michael Shepard, Catherine Shepard versus County of Los Angeles, 2021 CalWork Comp PD Lexus 151 was a case that found a motor vehicle accident resulting in the death suffered while driving between the home and a self-procured chiropractic appointment was the type of treatment for an industrial injury such that the automobile accident was considered AOE-COE. Now, that isn't so surprising to most of us as practitioners in regards to travel to and from an industrial-related appointment is going to be considered industrial in nature if there's any type of harm suffered. I've personally litigated those cases on the defense side. However, a self-procured treatment without a finding that treatment itself was both reasonable and necessary to treat, cure, or relieve the effects of an industrial injury, that seemed a little more tough in regards to the line. Specifically, it's going to be hard to prove reasonable necessity in light of the fact that the applicant's no longer with us. And it makes me very concerned that if it was self-procured, it would be why, right? If it's an accepted claim, then why isn't there a chiropractor providing treatment for this applicant already? I'll take it a step further. These facts aren't here, but what if the chiropractic treatment, which was self-procured, was outside of the self-prescribed statutory cap? Then what? Can you have an industrial-related self-procured chiropractic treatment that is statutorily barred from being provided, as it is beyond the number of chiropractic treatments, such that even though the insurance carrier cannot be forced to reimburse for it, they should be forced to reimburse for the death or injury which is caused from the travel to and therefrom? I don't know. I don't know. Obviously, I never want to leave any family that is in need and who's lost a breadwinner, specifically as a result of anything related to a workers' comp injury or anything related to their work. But in the same point, I wouldn't want a small business owner to have to pay more than what is owed in any one of these specific instances, And it's just something to think about here, because in this one, the court said it's self-procured, but it was industrial related and therefore part of the workers' comp injury. Well, we're going to cut to another break, and then right after this, we're going to analyze another premises line liability case, tie this all in, and close out. So we'll be right back right after this.
Trusts aren't just for the super rich. It can take a year to probate a modest homeowner's estate, eating 6 to 8% of the estate's value. A trust can speed things up and preserve assets. The Sexton Law Firm.
Outside of making the choice that you want more out of life, nothing's more important than education. The vast majority of what we provide here at Alpha Research is education, and it's my personal belief that education will take you from where you are to where you want to be. I can take this proven program of success and apply it to your situation and help you achieve the same results. But don't take it from me. Take it from our most recent Alpha Research success story.
Nick has helped me a lot with the way that I see myself and the way that my confidence comes true, and motivating me to keep trying to succeed, even though a lot of the time, law school can be very hard on you. But he's always there to encourage me and motivate me and help me out whenever I'm feeling a little bit defeated. I would recommend his program to anyone. I think that Alpha Research is an incredible product, an incredible company. If you're ready to take the next step and become a better version of yourself, Nick is here for you, and he's willing to help you show your true potential to the world.
What you just saw isn't one individual success story after taking our educational success ladder program. The same could happen for you, and all you have to do is take the steps necessary and click the link below. All right, and we're back. Thank you for sticking with us. We were just covering a case right before we left, which involved a motor vehicle accident coming and going from self-procured chiropractic appointment. And the court said yes in that situation, AOE, COE, in regards to the death claim. We have another case coming out of the Fresno area in the Central Valley where a worker was injured on the way to work in a vehicle that the worker believed was owned by the owner of the farm, but the motor vehicle accident to and from the work, although the belief that the ride was being provided by the farmer and that the ride was part of the employment, it was not, and therefore that case was not compensable. They looked at both premises liability in regard to that and noted that it was not the farmer's truck, the van, and it was also not on the farmer's premises when this occurred, and that the individual in question only had piecemeal work at best and wasn't a consistent employee. Now, in reconciling those two cases, it's quite obvious that one is either is or is not directly related to employment, and the other is or is not directly related to employment, right? So the farmer and the agricultural worker on a piecemeal basis, I think there was a twofold harm there in the sense that, one, the vehicle wasn't actually the farmer's, and if it was, it probably would have been considerably more tough for that defensing of that case. And two, even if that vehicle was the farmer's, if it was being used in some type of personal capacity between these members and it wasn't actually to or from a job site directly in relation to the employment, the question becomes whether or not that travel itself specifically was at the direction or incidental employment as to fall outside of the coming and going rule, right? Because we all drive to and from work, and that all of us that drive to work, and that trip technically is not generally part of the workers' compensation system. Notice how in that one case we discussed earlier that because it was to and from a chiropractic appointment, then all of a sudden, yes, it becomes work-related. Same thing with marijuana uses, right? If you're using marijuana, it's not related to pain, it's not related to your work claim, then you're just using marijuana. But it's quite clear in some of these states, specifically in New Mexico, where there's now an actual fee schedule, that if you get hurt in the job and you end up needing to use marijuana for pain, then your marijuana use will be incidental to your workers' compensation claim and therefore is compensable. And in fact, it's compensable according to a fee schedule. So with that kind of mindset, then you can see that if the travel isn't incidental to your actual job, right? You're coming and going from your job. It's not incidental to a job, it's incidental to where you live, right? Someone who lives in an apartment across the street ostensibly could walk across the street, right? They're not going to be charged with liability if somebody was hit crossing the street to go towards their work, not unless that specific property or employer created some heightened risk, which subjected that employee to a greater likelihood that they would be hit by that vehicle. And in that instance, you might have a fighting chance. So to bring it full circle here, the question is kind of left to you. Marijuana, does it belong in our California workers' compensation system? I don't know. I don't have the answer to that. I think we'll see as time develops. You'll actually see the tune of, I think, the insurance company change as to it when they're forced to compare the prices between opioids and marijuana. And on that note, I just want to say thank you for tuning in. And this is The Legal Giant Show.
Undercover lovers infecting the industry, and even undercover others that give you the ministry. I know that I ain't perfect, I know I'm a synergy, but I'm hoping if you listening, you feeling my synergy. Amen. Many, so many. Wish the worst on me. Wish the worst on me. Till I bring that major pain.